Hello, everyone. Welcome to another live session about immigration to Canada and the latest updates. Before everybody joins and you start asking your questions, I just give you some updates. The first update is about TR to PR pathway. If you recall, the government of Canada announced that they are going to accept a group of temporary residents to become permanent residents in Canada because of the current situation of COVID-19. And they called it TR to PR pathway. TR stands for temporary residents, PR permanent residents. So it's a pathway for certain temporary residents to become permanent residents in Canada. Generally speaking, this program covers 6 groups, but 3 of those groups are just duplicates of the first 3 groups. So the first group is the people who are basically healthcare workers in Canada, and those healthcare workers, they have been here and in the past 3 years, they worked at least for 1 year. The government is going to accept 20,000 applications under that program. So far, 1,295 applications have been accepted or submitted. So it means that there is a ton of room for people to apply if they are interested to apply as a healthcare worker. In terms of essential workers, which there is a job list. If you belong to that group, again, you need to show in the past 3 years you've had at least 1 year of experience as an essential worker. And that group, the cap is 30,000. And so far, they have accepted 8,452 applications. So it means that we still have more than 21,000 applications left open. So that's good news. The third group are international students. The cap was 40,000 people. Unfortunately, the cap reached in about 27 hours from the moment that they opened accepting applications. So for now, there is no opportunity for those people. However, if you are a Francophone and you fall under the either healthcare program or essential workers program or international graduates, you may still apply, because for Francophones, there is no cap and it's unlimited. In fact, under healthcare program for Francophones, only 22 people have applied. But it doesn't matter how many people, even if 20,000 apply, it should be okay because there is no cap. In terms of essential workers, only 314 people under the Francophone program have applied, and under international graduates, only 141 people have applied. So if you are an international graduate, it means that you have graduated from a valid designated learning institution of Canada in the past 4 or 5 years since January 2017. And then after that, you also, when you were studying full-time with a study permit. And then now you are inside Canada at this moment and you're eligible to work in Canada, and you are working for an employer. And also you take a French test and your result is NCLC 5 or higher under every skill of language. If that is possible for you, then you can still apply under the international graduate program, because there is no cap for Francophones. If you are not a Francophone, unfortunately, the international graduate program is full. Having said that, recently, at least according to CIC News website, the Minister Mendicino is considering increasing the cap. So if that happens, we may still see some opportunities for international graduates. Stay tuned. I have an article on our website that I post updates about this program. I'll do my best to update the statistics also fairly frequently, maybe several times a week. So if you want to know about the latest updates, if the Mr. Mendicino actually announces that he's going to increase the cap and they really increase the cap, I will post it on the link that I just posted on the chat box. So that's the first piece of news. The second piece of news is about express entry. With the express entry system, as you know, or probably know, since January, unfortunately, the government of Canada decided to not to invite federal skilled workers or federal skilled trades. So the only groups of people that are being invited either are those people who have already received a nomination by a province, so it's PNP Express entry, or people who have applied under Canadian Experience class. The reason for the shift in the decision process is because of the fact that still the borders are closed and people cannot travel to Canada. And majority of FSTC or FST applicants and FSW or FSWC applicants, they live outside Canada. However, 90% of Canadian Experience class applicants, they are inside Canada. That's why their focus is on inside Canada. In the last draw, the government invited more than 4,000 Canadian Experience class applicants, and the score remained around 400. In fact, the lowest score was 401. So it was 1 point higher than the previous round, but still in the same area. So if you qualify for Canadian Experience class, it is still a great opportunity for you because you're not competing with federal skilled worker or federal skilled trades applicants, and that will give you an edge. So consider that if you qualify. If you do not qualify, still continue. The other issue, because people constantly ask me about spousal sponsorship applications. So the government initially made an announcement back in October that they are going to increase their workforce who work on spousal applications. And we actually saw good progress in terms of those applications. But then later on, unfortunately, because of the issues that we encountered, like the lockdown in Ontario, that CPC Mississauga is located, and it handles in Canada cases, and also increase of the cases in Nova Scotia, that's Central Intake Office is located, which accepts outside Canada cases. We have seen a slowdown, even with visa posts, for example, visa posts in Ankara, visa posts in New Delhi. These visa posts pretty much do not process any applications at this moment because of the increase of the number of cases. We have the same situation in Mexico and many other countries that are highly affected by coronavirus. So unfortunately, at this moment, we have to wait for this situation to ease up. If you have submitted an application for a spousal sponsorship, don't get disappointed. It will be processed. The government promise is 12 months. They may probably go over 12 months for most cases, but that's the reality of coronavirus and how it affected the immigration process in Canada. For parental sponsorship cases, unfortunately, there is no news in terms of accepting new applications. The government had promised to accept 30,000 new applications this year. No sign of when they are going to make that happen. Last year, they opened the online application process, or expression of interest around October. I believe it was October the 13th when they did that. So there is a chance that they do the same around October this year, but they may open this sooner or later. No sign of when they will actually start accepting parental sponsorship cases. And if you already have an active parental sponsorship case, then good luck with that. The processing will be delayed. Now, but before I go to the questions, because I forgot to introduce myself in the beginning, my name is Al Parsai. I'm a regulated Canadian immigration consultant, and I'm the author of the book 88 Tips on Immigration to Canada. You can purchase it from any Amazon website. It's pretty much available on all Amazon websites all over the world. And I'm also happy to announce that I'm going to teach a course at Ashton College, and that course is called Advanced Course in Admissibility to Canada. So if you are a practitioner, for example, if you are an immigration consultant or an immigration lawyer, consider registering to that course. I will discuss different aspects of inadmissibility to Canada, and I will also talk about remedies to inadmissibility. If you're interested, this is the link that I just posted on the chat box, and you can click on it and see if you're interested to consider registering to this program. It will start on June the 2nd. It will be every Wednesday from I believe 4 to 7 p.m. Vancouver time, because Ashton College is located in Vancouver. I'm in Toronto, but the course is online, so I will connect online and the students will also connect online. Okay, so hi Andy, good to see you here. Hi Mr. Will. So Mr. Will says, good morning. If I'm paying student debt in America, am I qualified to apply for PR in Canada? So obviously I cannot offer immigration advice here. I really don't know what's your situation. And the reason I'm saying I don't know, because I'm going to share with you the story. One of my clients long time ago, when we were signing a retainer agreement, he told me that he had a case, that case was, and that he got married to a lady in the United States to immigrate to the United States, but that marriage fell apart and they got a divorce. So very simple. I said, okay, that's fine. So let's just get show me the certificate of divorce and we are good to go. That's fine. People have the opportunity to get married, get divorced, whatever, and we will go ahead with that. Then after we signed the agreement, he revealed to me that, you know what, there was a reason that I left the United States. I said, what was the reason? He said that, yeah, I borrowed money from casinos in Las Vegas and I owe some money to these casinos, and that's why I decided to leave the United States. I couldn't pay them back. I said, okay, now this is a different situation. We need to explore that. And when we explored that, guess what? He actually owed more than $60,000 to a casino in the United States. And there was a court case against him. He was charged and he was convicted on different fronts. And he was, in fact, inadmissible to Canada on grounds of criminal activity in the United States. So it wasn't about a debt. It was about the fact that there was a criminal history for him in the United States. So I cannot, even if I wanted to offer you advice, I wouldn't have done it this way. I would have digged into more information about the debt. So this is one of those cases that you definitely need to book a consultation session with me. I looked into that and we will explore whether it is actually the debt will cause any kind of issues. I mean, if it's just a simple student debt that somebody is paying off, everything is on good terms, no no court cases or no court orders or anything of that nature, a mutual agreement with the school, it shouldn't cause any trouble. But I cannot just based on one sentence decide what would be the result, and it's not appropriate to comment on that online. But you can hire me for a consultation session, and I will tell you how to move forward to find out. Hi, Shanley. Good morning, Mr. Parsai. Nice to see you again. Nice to see you again here. So the question is that if an applicant receives his COPR while he is abroad, can he come back to Canada with the COPR? If not, can he travel with his existing PGWP, or can he go ahead to apply for a PR card? So again, I need to answer this very broadly. So first of all, just having a confirmation of permanent residence does not allow a person to travel to Canada. If that person needs a visa to Canada, then the immigration authorities will issue one PR sticker or counterfoil, and they will attach it to the passport of that person. So that's a single entry visa to Canada, which based on that, if it was not coronavirus, you can travel to Canada within the time limit that that single entry visa defines. And at the port of entry, a border services officer will validate the COPR, and you become a permanent resident of Canada. So that's the standard approach to this situation. Right now, the problem is that the immigration authorities do not allow people to travel to Canada just because they have a PR visa and a non-validated COPR. So unfortunately, that's not an option. The only exception is for those people who have been sponsored to Canada. So if somebody has been sponsored to Canada and that person application is approved and they have the PR visa and they have the COPR, then may travel to Canada and validate their COPR and enter Canada. But if the application was based on economic immigration, for example, unfortunately, that is not an option for now because of travel restrictions, not because there is something wrong with your PR visa or with the COPR. The COPR, by the way, for those of you who don't know, it's the short form of confirmation of permanent residence in Canada. In the past, they used to call it landing paper. The other issue that you need to know is that, of course, if somebody is from a country that they do not need visas, they don't receive a sticker or counterfoil in their passports. However, the officer will issue them an ETA if it's necessary, so they can travel to Canada and validate their COPR. Again, the same problem. If they try to travel to Canada, it is considered a discretionary travel, and that's why they won't allow them to travel to Canada unless the COPR is issued because of a sponsorship application. Okay. Now, for somebody who just is outside Canada, applying for a permanent resident card is not an option. The permanent resident card application must be initiated inside Canada. You cannot initiate the application for PR card outside Canada. Also, you can apply for a PR card only when you are a permanent resident. Just because somebody has received a raw COPR does not make that person a permanent resident of Canada. In fact, that person is considered a PR visa holder, not a permanent resident of Canada. And that's why a border services officer at the port of entry may refuse your entry to Canada. Still, because you are in this transition mode from a temporary resident to a permanent resident, but the final say that makes you a permanent resident of Canada is by the border officer that you encounter when you are trying to enter Canada with your raw COPR. That person will validate your COPR, and then you become a permanent resident. And after that, you are qualified to apply for a PR card. By the way, for those permanent resident applicants that are already inside Canada, The government right now issues them validated COPRs immediately, so their situation is different from somebody who is outside Canada. Now, the last option could be postgraduate work permit. Again, just because a person has a work permit does not allow them to travel to Canada. They need to show that they have a job in Canada, so they need to show a letter of employment. Honestly, because of the complications in this case, that if somebody has COPR and also has a job offer with a valid postgraduate work permit, it will be at the discretion of IRCC whether to allow that person to come to Canada or not. It is likely that they will allow that person to come, but again, just because of work permit, no, that person must also have a job in Canada. So I hope I answered your question. So this, the next question is Druik. I hope I pronounced your name properly, or at least I was close. Please provide information about spouse open work permit outside Canada. Unfortunately, there is no open work permit for spouses outside Canada. The only open work permit that is available, if you're talking about the spousal sponsorship applications, for spousal sponsorship applications, the only spouses that qualify for an open work permit, they are spouses of that they have applied under inland or inside Canada or in Canada class application. So if the spouse lives with the sponsor inside Canada, or the common law partner lives with the common law partner who is a Canadian citizen or permanent resident inside Canada, if they initiate the in Canada spousal application, that's when the spouse also qualifies for an open work permit. If you're talking about somebody who has a study permit or a work permit and their spouse want to accompany them with an open work permit, yes, that's doable. The process is relatively easy. It's just an online application, but you need to include enough documentation to prove that the worker is the worker is a skilled worker, and also, or if the student is an international student with a valid study permit. So you need to look into those based on the situation and decide whether the person qualifies for an open work permit or not. The open work permits that are issued for spouses of international students or temporary foreign workers in Canada are based on a public policy under the authority of Section 205 of the immigration regulations. And the success rate is relatively okay. Roughly speaking, I think about 70% of people get approved. However, sometimes people screw up. They don't properly explain the situation and they get refused, but it is doable. So Andy says, good morning. I already said good morning. Okay, Mahi Channel. So status about home child care provider pilot program for outside Canada. So generally speaking, if you want to apply for now home child care worker program, unfortunately, the cap has reached. The cap was about 2,750. They have already reached that cap. So they don't accept new applications from those people right now. And also, but the other one, which is a home support provider, that is still open and people can apply under that program. So the other program is for people who are taking care of elderly. But in terms of the processing, we have roughly a backlog of, I believe, 6,000 people, or I mixed up. It is 1,500 those people who are in the initial stage and 6,000 the later stage, or the other way around. But anyways, the minister has promised to make those backlogs zero by the end of this year. So hopefully, if you have already applied for under any of those two programs, which fall under the caregiver pilot from outside Canada, your application will be processed basically by the end of this year. Let's keep our fingers crossed that what the minister promised is actually gonna happen. So the next one, Zuka Lake. I hope I pronounced it correctly. Hi, sir. Please inform if a visitor to Canada can apply for a work permit under the new public policy if she can find an employer to work as a caregiver. Does employer need to do LMIA to hire her? So yes, there is a public policy that will be in effect until the end of August. If the visitor is inside Canada and they find a valid job offer, then they do not need to leave Canada to apply for a work permit. So let me briefly explain that to you, what is happening, because there is so much misinformation about this out there. Look, in the past, if you were a visitor inside Canada, you couldn't apply for a work permit from inside Canada because that contradicts Section 199 of the immigration regulations. Okay, so for visitors, this was not an option. There were some methods to apply for a work permit, like flag polling, like applying on paper to a visa application center in the United States. Those options were in place, but after coronavirus, those options do not exist. And that's why the government came up with this policy that said, for now, if you're a visitor inside Canada and you have valid visitor status, you may apply for a work permit from inside Canada. That doesn't basically waive you from any of the requirements of the work permit. So the only thing that they have waived is the location of the application. You can apply from inside Canada. That's it. So you still, depending on the job that you receive, you still need a valid LMIA. If it's an IMP, you need to show that this is an actual IMP, etc. And for caregivers, by default, if you are a caregiver inside Canada, then you need to apply or your employer needs to apply for an LMIA. And because generally speaking, caregivers considered low-wage jobs, getting a work permit, a positive LMIA for caregiver is so difficult from inside Canada, if not impossible. But anyways, it's yes, they could apply for caregiver from inside Canada, but they need to go through the process of LMIA. If the other option was open, which was basically the option for caregiver pilots, then you could go through that. That one didn't need an LMIA, but unfortunately, that option is right now closed. And even before that, it was a very time-consuming process. Okay, so where am I? The next one, my visitor visa has refused. Can I apply for working visa? So obviously this is from Laxman Tapa. So I cannot offer immigration advice and I have no idea why your application was refused. So obviously I cannot tell you what you can or you cannot do, but I can give you generic information. If if any application has been refused, now, there are two major reasons that the officer refuses the application. One reason is that you do not meet from the point of view of the officer, you do not meet the requirements of that application. For example, for a visitor visa, they might say that we refuse your application because you do not meet the requirements of Section 179 of the regulations. In those situations, obviously, you can, right after refusal, then very next day apply for another temporary resident visa or work permit or a study permit, assuming that you meet the requirements, you have enough documentation, or you can apply for immigration, whatever. So refusal based on the merits of application, based on whether you meet the requirements or not, usually does not impose any limitations on the person to apply for the same application type or other types of applications. So that's a very generic. Obviously, we need to look into that case as well and see what were the concerns of the officer, and then try to address those concerns before we just jump into submitting another application. And for example, for a visitor that is refused and now they are applying for a work permit, obviously they need to go through the process for work permit. For example, a positive LMIA, IMP exemptions, etc., before they can apply for the work permit. The other reason for refusal could be inadmissibility, and that's the one that I will discuss in my course through Ashton College. So for those of you who just joined us, I will post the link here. If you're interested, if you're a practitioner, you can attend that course. I'm going to, in details, explain the reasons that people become inadmissible to Canada, and pretty much all the solutions to those inadmissibility options. So if the person is refused because of inadmissibility, then that's a huge problem. And you cannot apply, simply just go and apply for another work permit or study permit or visitor visa. So many people, I think on a daily basis, I receive messages from people that their application was refused based on misrepresentation. Misrepresentation makes you inadmissible to Canada for 5 years or 16 months. And if somebody receives a misrepresentation refusal or any other kinds of inadmissibility refusals, for example, refusal because of criminal history, because of medical issues, because of financial issues, whatever the reason is, unfortunately, you cannot just apply for another work permit or a study permit. You need to address that inadmissibility first, and that could be, depending on the situation, applying for rehabilitation, deemed rehabilitation, TRP, HNC, ARC, or sometimes a combination of all of those. And in certain cases that it's a severe situation, ministerial relief. And of course, this is the job of a professional consultant or lawyer that understands inadmissibility, can analyze your situation and decide how to help you come back to Canada. I hope I answered this question. So Shanley says, thanks, your advice is very clear. In my case, about, let's say he has a job offer, can he travel to Canada with his PGWP and get his COPR validated at the border? Again, Sean, I honestly don't want to accept, any responsibility by offering advice in a public forum. If I'm going to offer advice, that needs to be private, paid, signed, go ahead. And I will give my official advice. But what I can tell you is that generally speaking, a person with a work permit and a job offer in Canada could travel to Canada because travel restrictions do not apply to them. What will really happen in real life, it depends. I've seen so many crazy things happening in the past 1.5 years. Believe it or not, I even have a case that I got the referral from CBC, which is the Canada Broadcasting Corporation, that we are dealing with that refusal, that you just scratch your head why that person was denied entry to Canada. So everything is blurry in this day and age, but generally speaking, a person with a valid work permit should be okay if they have a job offer to come to Canada. So the next question is, I think I missed something. How long does it, where I am? This is Mesero. How long does it take right now to apply for Kuzma work permit? After sending my Kuzma work permit application, can I apply via IRCC web form for 2-week pre-authorization to start the Kuzma job? So it depends the kind of Kuzma job, because under certain situations, you can apply from inside Canada. You can request expediting the process. And also in terms of starting the job, honestly, it depends on IRCC. Of course, if somebody already has a work permit and they are applying for a new work permit, then they may start their working right away. But if they are visitors, they need to stay tuned for the officers to decide. Nowadays, I would say for probably 90% of my applications, they issue a temporary work permit, and that temporary work permit allows them to work in Canada for about 3 to 4 months. And then within that 3 to 4 months, they finalize their application. If you're interested to know more about this temporary work permit, and I know that every work permit is temporary. I didn't know what to call this temporary work permit, but this is the link to my article. You can read that. It gives you more information. And by the way, for those of you who don't know what Kuzma is a treaty between Canada, United States, and Mexico about so many different things. But under the immigration law, we care about labor movements and specifically working. So if as a Canadian, I want to work in Mexico or in the United States, I can benefit from the terms and conditions of Annex 16 of Kuzma. Kuzma used to be called in the past NAFTA. And by the way, right now, if you go to the United States, they call it USMCA. If you go to Mexico, they call it TMEC. But at the end of the day, it's NAFTA 2.0. And that only applies to the citizens of these 3 countries. So the next question. So Sean, I think this is a repetition of your question, so I'm gonna pass. So Hossein Mamadi, where can I find information about housing for refugees in Canada? Can you explain where they exactly can get housing? So basically, in Canada, when somebody shows up at the port of entry, for example, and they want to file for refugee, Canada does not have camps. Of course, under some certain situations, they may put that person in prison for a while. And that's more about identity, situation, etc. So there is a slight chance that they detain a refugee applicant when they file for refugee, especially when they file for refugee at a port of entry. But it's very rare to do that. The previous government of Canada tried to increase the number of detention for refugees to discourage refugees from filing for refugee at the port of entry. That situation has subsided right now. With the exception of some rare occasions, they do not detain refugees. But in terms of a refugee, when they come to Canada, they do not actually put them in camps. Canada does not have refugee camps. However, we have 2 different kinds of refugees. Some of them, they have a family or friend or a support group that they will give them or provide with them with a shelter, etc. But if those things do not exist, then the immigration authorities may transfer that person to a temporary shelter. And then through that temporary shelter, they'll find them housing. Those housings are usually a collaboration between Canadian cities or provincial authorities and the federal authorities. And nobody can tell you exactly where, because here in Toronto, we have so many different sites that a refugee could be housed. But it's not like that there's a building dedicated to refugees. Normally, we don't do that. Again, because this is a city initiative, in different cities it could be different. But in Toronto, most of those refugees, if they don't have any place to live, they will be just go to one of the co-op buildings, and those co-op buildings are usually given to people that their financial status is not very good. So it's not just refugees; it could be a Canadian citizen as well. That's pretty much it. But generally speaking, I could say that somebody who comes to Canada and files for refugee shouldn't be that much worried about their housing if they don't really have coverage. And by the way, they will also eventually issue a work permit for those refugees so they can work and they can make money and they can become independent. And I have many refugee clients, and none of those refugee clients that I have, they actually live in a shelter or in a co-op house, partly because they either have family members here in Canada to support them, or they are working. And because they are working, they can actually afford renting a place or at least a room or something. So the next question is from Kuldip Jill. Sir, my postgraduate work permit application has transferred to local visa office in Saskatoon, and it's taking so longer time to process, has been more than a year. What can I do? Please advise me. Of course, I cannot offer immigration advice in a public forum, but generally speaking, when they transfer that to an office, it could be a background issue or something like that. And the best course of action is to get in touch with that office directly and ask them to expedite processing. If somebody hires me to deal with those situations, what I normally do is that I will request the GCMS records of that person to see what triggered this transfer. And then based on that, I try to communicate with the authorities and encourage them to expedite the process, or I will explain the situation to my client and will tell them what to do or what not to do. But generally, a generic answer would be communication with them. But specific, I need to know what's going on with that case. So the next one, Hiram Patel. I have applied in self-employed visa from India and got file number not temporary in March 2020 and also paid biometric fees, but still no any action after that. How much time it will take? So again, I cannot talk about your specific case, but generally speaking, if you're talking about federal self-employed class, the processing time used to be around 23 months, 24 months. And in fact, many of my clients were processed under 2 years, but the situation has recently changed, especially because of COVID-19. Majority of visa posts do not process applications. If you received a file number in March 2020, I suspect that they have not even transferred the package to a visa post yet. I may be wrong, of course. And then the visa offices, they currently rarely process federal self-employed applications. And because of that, the processing time is now increased to about, I believe, 34 months or so. So it means that we are getting closer to 3 years of processing from 2 years of processing time. What will really happen to a specific case, we never know. I mean, under federal self-employed class, I've had a case that was processed, and I'm talking about my successful cases, not refusals. I had a case that was processed in about 6 months. So from the day that we submitted application to the date that they received their passport request was about 6 months. And I've had a case that the processing time took 53 months. Or more than 50 months. I don't remember, was it 51, 52? I think it was 53. So imagine from 6 months to 50 months. How can I tell you what would be the processing time? There is no way we can predict that. Even for refused cases, there is no way to predict them. I've had cases that were refused only 2 months after submitting the application, and cases that were refused probably 4 years after submitting the application, or maybe even more than 4 years. So unfortunately, there is no way anybody can predict the processing time. Having said that, keep that in mind. The self-employed application is one of the most complicated applications that you could submit to the immigration authorities. It's up to you, but if you have not received help from anybody, I highly recommend that you get help from somebody who knows this program well to review your documents and give you suggestions as to whether this is enough or not, or what kind of steps you need to take. So Hussein says, can you fix admission in Ashton College for me? So Hussein, first of all, I'm an instructor over there. I'm not an administration member, but Ashton College is not offering immigration diploma anymore because ICCRC decided to transfer everything to Queen's University for the immigration diploma. So starting from, in fact, this January, the only entity that offers programs of the diploma for immigration consulting is Queen's University. So you need to get admission to Queen's University if you want to become an immigration consultant. In terms of the courses that I teach at Ashton College right now, the courses that I teach, they are the residues of our previous program. So in other words, we had some students that they registered last year, and they still their program is not finished. And of course, ICCRC allowed us to teach them to finish their program, get their diploma. Of course, their diploma is valid and they can become immigration consultants with that diploma. But we don't have new registrations. In fact, starting from, I believe, August 1st, 2020, Ashton College and all other colleges and universities that they offered this program, they stopped accepting new students. So I also teach some other courses, and those courses are advanced courses. But we deliver those advanced courses for only people who are currently licensed. So like this one, the advanced course that I'm going to teach for in terms of inadmissibility to Canada, this is only for immigration lawyers and immigration consultants. So my students are actually, they are not students. I even do not call them student. They are my colleagues. That happens to be that we sit together and I talk about the subject and we learn from each other. That's the kind of courses that I teach right now, advanced courses. Of course, I have a couple courses left, actually one more course left. I'm honored that Ashton decided to give me the very last course of their IMCD program to me. So I'm going to teach that course in this summer, and that will be the last diploma course. We will also run some makeup sessions for people that they finished their program like 2 years ago. Now they want to take the test. They need to refresh their minds before they take the EP test or entry to practice exam. Ashton will offer those courses. They are allowed to offer those courses, but no IMCD. So I hope I answered your question. Okay, so the next one, oopsie, I lost it. So Felix Dion, hi Parsai. If I have a job offer from a Canadian company, can I apply for a work permit at the port of entry without having the employer fill out any paperwork? So when applying at port of entry, am I able to work right away, or do I need to wait for the permit to be processed? Okay, that's a good question. So unfortunately, right now, the answer is no, because of travel restrictions, not because it is not doable. So at the port of entry, if somebody is exempt from the requirements of a visa to Canada, they may apply for a work permit at the port of entry. There are some exceptions to that rule. For example, if the application is a very complex kind of application, they refuse to process it at the port of entry. And these are all also defined under Section 199 of the regulation, sorry, 198 of the regulations. But right now, and by the way, if you are from a visa required country, even before COVID-19, you were not allowed to apply for a work permit at the port of entry. You had to apply online before entering Canada. But after coronavirus, the CBSA officers do not process work permit applications at the port of entry. We have called them a couple of times, and they said, no, we're not going to process work permit applications at the port of entry. So if somebody shows up with a job offer, of course, the job offer needs to be valid. For example, it is supported by LMIA or it is IMP, whatever it is, you have all the documents and everything in place. But when you show up at the port of entry, they will refuse to process your application at this moment. In fact, in some serious cases, you may face a removal from Canada. So you have to be very careful in terms of showing up at the port of entry, hoping that they will issue a work permit for you. This could change at any moment. Tomorrow, this policy could change. I don't know. So that's why you need to constantly monitor their website, CBSA website, IRCC website, and see if anything changes. or maybe ask the employer to contact CBSA directly and ask them for guidance. If they say, yes, we will process, you can come. And again, I emphasize, you need to be exempt from the requirements of a visa to Canada. Otherwise, you cannot apply at a port of entry. And nowadays, because of coronavirus, you cannot apply. In terms of your second question, for people who receive their work permit at a port of entry, they immediately receive the work permit. So they literally print the work permit document, they pass them to the person, and that person can start working in Canada right away. Now, nowadays, of course, because of coronavirus, depending on the nature of the job, you may need to self-quarantine in a hotel for up to 3 days, and then self-quarantine again for another up to 14 days in another place. And while you are self-quarantining, obviously you cannot work unless the work is online, and your employer needs to pay you. There are some exceptions to that. For example, healthcare workers, they do not need to isolate or quarantine, and they can immediately start their job because of coronavirus situation. Again, this could change at any time. So I think, Sean, this is again a question repeated about COPR. Let me see if I can answer. I have only 9 minutes left. So good morning. Is there any news about ICT from US to Canada? Nothing new. No, same old, same old. Do I need IELTS? The next question. What docs the employer should issue to apply for Kuzma professional work permit? So it depends on the situation. I cannot go into the details of that. This is a very professional kind of thing, and of course that's our line of livelihood. But at the end of the day, they need to prove that they are a qualified employer. In other words, certain documents for business legitimacy. The job offer is a genuine job offer, and the person qualified as a professional. And Annex 16 has a table. They clearly say, if this is your job, these are the qualifications that we accept in terms of your education, etc. So you need to present all those kinds of documentation to convince them that you meet the requirements. But I won't go into the details of it. So do I need... so this is from Nilan Groy. Do I need IELTS to get admission in master's if I have bachelor's degree from the USA? So the simple answer is that this is based on the policies of the university or college. For example, if you want to get admission to U of T, University of Toronto, it depends, of course, on the program that you're registering to. They may say, even if you have graduated from a university in the United States, your GPA must be higher than such and such. For example, B+. So it's not just that graduation from an English-speaking school does not necessarily eliminate the need to take an English test or French test. However, I would say probably in most cases it does. And the only way that you can find out is to directly go on the college or university's website and see what is their policy in terms of those people who have completed a program in English language from, for example, a US university or college, and then based on that decide what to do. From an immigration point of view, with the exception of SDS, a study direct stream, there is no need for IELTS test or another language test to get a study permit, although it helps because it convinces the officer that you actually qualify to study in Canada, but it's not mandatory. For SDS, it is mandatory. Whether you have completed your program in the United States or the UK or Ireland or anywhere else in this world, if you're applying under SDS or a study direct stream, which is limited to residents of 7 countries, in that situation, you definitely need to present IELTS test results or self-pip test results or TEF Canada or TCF Canada, and your score under every ability must be NCLC 7 for French test and CLB 7 for English test. But that's a requirement by IRCC for SDS applicants only. If there are other applicants, it's not mandatory. So Hiren says, thank you, sir. If self-employed file number they have issued, then they may refuse my file without asking any additional documents. So the simple answer to this question is they do that, although it is not fair because I don't want to go into the details, because if you look at section 88, there is a loophole in section 88 that mandates all the officers, if they have concerns about an application, to request more documents and then decide on the application. But unfortunately, some of the visa offices may do the otherwise. It's not that common. For example, the visa office in Beijing, they pretty much all the time interview the person before deciding. The visa office in Singapore, they interview people before deciding. The visa office in Milan, in Rome, they actually ask for more documents. The same thing is visa office in Paris. The visa office in Ankara sends a document checklist and asks for more documents. But unfortunately, visa office in Warsaw refuses the applications without asking any specific documents. And that's why we have filed a huge judicial review case against the visa office in Warsaw. So far, more than 90 people have joined that judicial review, so it's a huge case. Hopefully by the end of summer we will have a hearing, and the decision of that hearing will give the better answer to your question. But right now, to the best of my knowledge, with the exception of visa office in Warsaw, which is in Poland, the rest of the visa offices, they either request more documents in writing, or they sometimes interview the person. That's customary, but you're not 100% protected. Okay, so if possible, claim 50 points CRS if a person is working under employer's specific work permit, closed work permit, not completed 1 year with same employer, current work permit. So this is the question by DM. So look, the 50 points, it depends which 50 points you are asking. If it's a 50 points because of a job offer, for job offer, you don't need to work 1 year in Canada unless the work permit that you received is under International Mobility Program. So if it's an LMIA-based, employer-based job, then you don't really need to work 1 year. You just need a job offer from that employer in writing that they want to extend the job to the person for at least 1 year after they become permanent resident, and you receive your 50 points. But if it's an IMP, then you definitely need to work for 1 year at least, then they can give you a job offer. But if you're talking about qualifications for Canadian Experience class, if somebody has not completed 1 year of full-time work in Canada, then they do not even qualify for Canadian Experience class. They need to apply under Federal Skilled Worker class, which they do not invite them right now. And the other issue is that in terms of claiming points, you need to complete at least 1 year in Canada to receive your 40 points, or if you are alone, or 35 points if you are married or in common law relationship because of your work in Canada. On top of that, you could receive up to another 100 points because of a combination of your work in Canada and your past work experience and your knowledge of English or French languages. So that 1 year working in Canada becomes crucial because makes the person qualified under Canadian Experience class and increases their points for up to 140. And also on top of that, regardless of whether it was an LMI-based job or IMP, they qualify for receiving a job offer, and if they receive a job offer, they receive another 50 points or 200 points, depending on the job offer. So good to know that Ashton College is allowed to offer the refreshing courses. Do you know how long Ashton is allowed to continue such courses? So I would assume that because when you graduate, you have up to 3 years to take your EP exam. So I assume the last group would be in 2023. But again, we need to see if what will be the decision of ICCRC. For now, they are okay with that. So the next one, how to apply as a couple in conjugal relationship. Well, that's a course on its own. I've had some clients that they were conjugal partners. Honestly, I cannot briefly explain it here, but it is possible. They just need to show enough documentation that the relationship is genuine, and also they need to show enough documentation that they cannot cohabit. So that's a simple answer to that, but it's a complex thing. So what is the processing time for ICT? Honestly, nobody can answer this question right now because I have cases that they have been waiting for a very long time to be processed, and partly it's because of the fact that some of the visa posts, they do not even process applications. So I'm out of my 1 hour, but I'll just answer these couple of more questions and we go. So Martin Boberg, I have a question about the time in Canada for citizenship as a refugee. Is it 2-day call, 1-day rule for the time before you get your refugee approval, or from the time before your PR card is issued? So basically, citizenship is one of those areas that I don't practice that much. But I can give you the answer. I think, let me not to guesswork because I don't know the answer to this question. But if you look it up on IRCC website, my understanding is that you need to have temporary resident status. But maybe I'm wrong. And refugees do not have temporary resident status. So to be on the safe side, please double check with IRCC website or talk to somebody who knows citizenship in details. So the next question, is there any other province except 6 months working experience besides Saskatchewan in Canada? Not that I'm aware of. Are you available today for booking consultation? I think so. Today is Sunday. But anyways, because somebody also asked about my contact information, it's very easy. Just visit our website, settler.ca. And basically, you can find all our contact information over there. And if somebody wants to book an appointment with me, this is the link to the appointment. Actually, I want to give you an offer that offers you 40% on booking an appointment. But so just visit this. This is a temporary offer, so we can remove it at any time. We might remove it tomorrow, but right now it's available. And I honestly don't know if I would be available today, but I will look into that. If you purchase a consultation session, I'll try to make it happen as quickly as possible. Okay, so thank you very much. I already passed my time and I have another commitment. I need to take care of that. Thank you very much for attending this live session. Just as a reminder, every Sunday at 10 a.m. Eastern time, which is the Toronto time, I will run 1 hour live sessions on YouTube. My intention is to go back and create also videos and post them again. So I know that I've been away for about 2 or 3 weeks for other kinds of videos, but I will come back. I'm extremely busy for some reason. All my hearings are scheduled within the next few weeks, and that takes a huge toll on me. I need to pay attention to my clients and make sure that we have successful hearings. But I'll do my best to publish more videos. If you speak Farsi, Persian, Iranian language or Afghan language, then you can actually also attend my live sessions every Friday on Instagram. And our Instagram handle is at Parsai Canada. Um, Actually, most of the followers on Instagram, they speak Farsi. So if you speak Farsi, you can also join us on Instagram. On Fridays at 10 a.m. Eastern Time, I answer questions on Instagram. Again, if you are also a practitioner, consider registering to our advanced course on inadmissibility. I start on June the 2nd, and you can support me by purchasing my book, booking consultation sessions with us, or hiring us. Thank you again. See you next week.